Hello everyone, welcome back to our channel Lawyer Stuffs. Today we are back with another video. This video is on one of the most important and famous cases in India, that is Kesavananda Bharati versus the state of Kerala. This case outlined the essential or the basic structure of the constitution. The concept of basic structure came into existence during the judgment of this case. The validity of the 29th Amendment within the 9th schedule, Kerala's takeover of spiritual mutt's property, was also challenged in this case. This case was popularly called as the Fundamental Rights case. It continues the highest shot for the longest proceedings ever to possess taken within the top courts in India. The judgment of this case is considered as the most important judgment within the history of the Supreme Court that saved the India's democracy. This case was filed in the Supreme Court of India. Full name of this case is Kesavananda Bharati Sripadagalvaru and Ors versus the state of Kerala and AMR. This case was decided on 24th April 1973. The citation of the case is AIR 1973 SC 1461. Laws which were applied in this case are Constitution of India, Criminal Procedure Code, Indian Evidence Act 1872 and the Indian Contract Act 1872. The petitioner in this case was Kesavananda Bharati and the respondent was the state of Kerala. Let us firstly discuss why was this case filed. Swami Kesavananda Bharati, who was the pinnacle of the Hindu monastery Ednir Matha in Ednir district, Kasaragod, Kerala on Feb 1970, challenged the attempts made by the government of Kerala to impose various restrictions on the management of its property. Nanaboy Palkhiwala, an Indian jurist, convinced Swami to file this petition under Article 26, which is the right to manage religious affairs. It concerned the proper to manage religiously owned property without interference of the government. If we look at the background facts of the case, Kesavananda Bharati was the chief of a non-secular sect in Kerala. That sect had certain lands which were acquired under its name. A number of the lands acquired under its name by virtue of Kerala Land Reforms Act 1963, which was further amended by Kerala Land Reforms Amendment Act 1969, were to be acquired by authorities for the fulfillment of their socio-economic obligations. Therefore, on 21st March 1970, the petitioner moved to the Apex Court for the enforcement of rights under Article 25, Right to practice and propagate religion, Article 26, Right to manage religious affairs, Article 14, Right to equality, Article 19(1)(f), Freedom to amass property, Article 31, Compulsory acquisition of property. When this petition was taken into consideration by the court, the regime of Kerala passed the Kerala Land Reforms Amendment Act 1971. However, the Parliament passed a series of amendments after the landmark case of Golaknath versus the state of Punjab. This was trained to overrule the Golaknath judgment. Within the year 1971, 24th Amendment was passed. Within the year 1972, 25th and 29th Amendments were also passed. Earlier in Golaknath's case, it was absolutely laid within the judgment that each amendment made under the Article 368 was to be taken as an exception under Article 13. Thus, to neutralize this effect, the amendment in the Article 13 of the Constitution annexed Clause 4 in order that amendment will have a bearing under Article 13. Clause 3 was also added to Article 368, which was, nothing in Article 13 shall apply to any amendment made under this article. In 25th Amendment, the word compensate was replaced by the word amount. Also, a brand new provision was added which said that Articles 14, 19 and 31 won't be applied in any law. And the 29th Amendment, which basically inserted Kerala Land Reforms Act into the 9th schedule. In line this, the matters which were associated with the Kerala Land Reforms Act are outside the scope of judiciary to do. All these amendments and the provisions of the Kerala Land Reforms Act were challenged within the Court of Law. There were three issues which were laid down before the Court of Law. Number 1, whether the 24th Constitutional Amendment Act 1971 is constitutionally valid or not. Whether the 25th Constitutional Amendment Act 1971 is constitutionally valid or not. And lastly, the extent to which the Parliament can exercise its power to amend the Constitution. And the contentions by both the parties on these issues are as under. Firstly, let us have a look at the petitioner's contentions. The petitioner contended that the Parliament cannot amend the Constitution during a way that they require to do, as they need a limited power to try and do so. The Parliament cannot exercise its power to amend the Constitution by changing its basic structure. The petitioner further pleaded for the protection of his property under Article 19(1)(f) of the Indian Constitution. And it was also argued that the 24th and 25th constitutional amendments provided under Article 19(1)(f) violated the basic rights. The respondent was the state of Kerala. It was contended by the state that the supremacy of the Parliament is that the fundamental principle of the Indian system, and the Parliament has the ability to amend the Constitution unlimitedly. The state also contended that so as to satisfy its socio-economic litigations, which are sure to the citizens of India under the preamble, it's important that the Parliament exercises its power to amend the Constitution. Finally, the judgment of Kesavananda Bharati case introduced the fundamental structure doctrine of the Constitution. It limited the Parliament's power to create drastic amendments which will affect the essential structure of the Constitution or the core values enshrined within the Constitution. The decision also upheld the ability of the Supreme Court of India to judicially review the laws of the Parliament. It also involved the concept of separation of powers, legislature, executive, and the judiciary. The Kesavananda Bharati case will be considered as a historic, fundamental rights case which prevented the nation from slipping into a totalitarian regime. Kesavananda saved the democracy, but sadly he lost his own case. It is the longest case in the history of India till date. The bench consisted of 13 judges, the most important bench ever to take seat within the apex court. The hearings consumed 5 months, though the end result profoundly affected the India's democracy. This case had been heard for 68 days. The arguments commenced on 31st October 1972 and ended on 23rd March 1973. It consisted of 200 pages. When the importance of this case was asked, former Judge of Supreme Court Justice K. Chandru told PTI, the Kesavananda Bharati case is critical for its ruling that the Constitution may be amended but not the fundamental structure. The judgment of this case ruled that Article 368 doesn't enable the Parliament in its constitutional capacity to delegate the function of amending the Constitution. This decision made all the deemed constitutional amendments stipulated under the legislative powers of the Parliament as void and inconsistent after the 24th Constitutional Amendment. This is a landmark case, and also the decision during this case outlined the essential structure doctrine of the Constitution. If you like this video, do like, share and comment down below, and do subscribe to our channel. Thank you.